Hello friends, myself Satish Dere, and here we're discussing the subject that is Evidence Act. Okay, so Indian Evidence Act is one kind of a procedural law, and it is come into force on 1st September 1872. Okay, so it is drafted by Sir James Stephen. Okay, and then Evidence Act is a not a exhaustive law, means it is not a complete law. Okay, then there are three principles of this act. First is the evidence must confine to matter in issue, means there must be relevant evidence relating to the matter. Okay, this is the first principle. Then second is hearsay evidence must not be given or admitted, but it is the general principle. There are some exceptions to that, to this principle. First of all, the first exception is the rest just time, which is given under section the 6. Then admission, confession, then dying declaration, then statement in public document, then evidence in formal proceeding, then statement of expert, which is thus given under section 60. It's proviso. Okay, these are some exceptions to the hearsay evidence, and here it is admissible in the Evidence Act. Okay, and third principle is the best evidence must be given in all cases. These are some principles relating to the Indian Evidence Act, and on these principles, our Indian Evidence Act is based. Okay, then we will just move forward to the our next section, that is the section first. And in this section, there are given short title, extent, and commencement. Okay, so in that section, the short title is the Indian Evidence Act 1872. It is one kind of the short title of the our act. Okay, then its applicability is given under the section, and its applicability is it is applicable to the all judicial proceedings, including the court martials also. But what is mean the all judicial proceedings? Judicial proceedings is one kind of uh, evidence which is which is or may be legally taken on oath. Means judicial proceedings definition is given under the CRPC in the section of 2 clause I. And judicial proceedings means nothing but the or evidence is or may be legally taken on oath, means nothing but the judicial proceedings. Okay, and it is also applicable to the court martial, but some court martials in the Army Act, Naval Discipline Act, then Indian Navy Act, and then Air Force Act. In this forces, when court martial is there, there is our Indian Evidence Act, it is not applicable. Okay, there are some subject is there where the our Indian Evidence Act is not applicable. First of all, it is not applicable to the affidavits, but it is a general rule. Okay, but there are certain provisions regarding to the affidavits where the Indian Evidence Act is applicable. Suppose in CPC of the 19 itself said that the affidavit is one kind of evidence. Okay, in CRPC there is there is two sections. I think three sections, that is 295 to 297, where the Indian Evidence Act is applicable to the affidavit also. Okay, these are the some exceptions to the regarding to the Evidence Act, which is applicable to the affidavits. Okay, then it is also not applicable to the our in arbitrator proceedings. Okay,